everybody. Happy Tuesday. Welcome to Let's Talk Live. I'm going to wait just a couple of seconds. I want to make sure I share this correctly to my page. Yeah, let's see. Okay. Oh, there it is. Okay. Share to share newsfeed. Share now. Okay. Alicia is sharing. Okay. It's official. Oh wait, I gotta go on Instagram too. Checking connection. You're now live. Hello everybody. Hi. It's me, Alisia Adamson Profit, here for Let's Talk Live. Woohoo! Just as a heads up, if you see my eyes going back and forth, it's because I've got one camera here for Instagram and one camera here for Facebook. But I'm really excited to see everybody today. Today's topic, if you've been following Hamlaw's page, is probation. I'm here to talk all things probation. I want to explain what it is it the right choice for you, what can happen if you're on probation, how to early terminate probation. As you know, Hamlaw is a full-service practice. We specialize in criminal defense, family law, and immigration. And as we often say, if you're running from police, immigration, or even your spouse, keep calm and call Ham. 407-802-3223. We would love to speak with you for any of your legal matters. So let's get into it. Let's talk about probation. What is it? Basically, probation is it's court-ordered supervision, and it's typically a part of a criminal sentence. You can take a plea to probation. Sometimes if you go to trial and you're found guilty, then the judge can sentence you to probation. And there are several different ways that you can be punished in the criminal justice system. Probation is just one of them. Other examples are jail, prison, community control, fines. Some people do get probation and community control mixed up. I like to just say that community control is probation on steroids. It's just a much more intense level of supervision. Sometimes it's house or ankle monitor, GPS monitor is included with community control. But today we're here to talk about probation and what probation entails. And so typically what you have to do with probation is you have to report to your probation officer monthly. Sometimes the times may go up or down depending on the relationship that you have with the probation officer, but it's typically a monthly report date. And pre-COVID, it was typically in person. I know now a lot of probation officers are allowing call-in, write-in, or even emailing in to check in with your probation officer. The first meeting is typically in person, but generally you do have to have a routine check-in with your probation officer. If you, say for instance, you get arrested in Orlando, but you live in Daytona Beach, or you live in Tampa or Bradenton or wherever, probation oftentimes can be transferred to those counties, but again, that's typically negotiated or worked out on the sentencing date. Another thing about probation is sometimes terms. You'll hear terms of probation. Those have to be completed while you're on probation, and those terms can be lots of different things. Sometimes there's classes. Sometimes there's evaluations, whether it's like a drug evaluation and recommended treatment, or a mental health evaluation and recommended treatment. Sometimes there's community service that has to be done. Classes like a DUI class or a battery class or anger management class, theft classes, and also fines. Maybe restitution as well, if the alleged crime includes some sort of damage that was done to a victim and that person needs to be compensated. Sometimes that has to be done while you're on probation in order for you to successfully complete it. Another term is typically you cannot use drugs or have weapons. Now, I have negotiated or put in conditions where there are exceptions to those rules. I have had like law enforcement officers that have been on probation, and because of their job, they have to have a weapon. So we put that in the terms and conditions that they are allowed to have weapons due to the nature of what they do for a living. Also, drug usage. For federal court, it doesn't matter. If you have a medical marijuana card, you still can't smoke weed while you're on federal probation. It is a violation. But for state probation, if you have a medical marijuana card, then oftentimes you can put that in the terms that if you do test positive for marijuana and you have a medical marijuana card, that does not count as a violation. You also have to notify your probation officer if you plan to travel out of the county. Again, sometimes that can be modified as well. If for some reason you work and you have to travel outside of the county often, you can kind of put a stipulation in there that you don't have to tell your probation officer every single time because you have like the dates that you're traveling. But as a general condition, if you're leaving the county, that is something that has to be reported to your probation officer. And also, you have to obey the law. That is the biggest one, right? Is cannot commit other crimes or get caught for committing other crimes while on probation. There are two types of violations. There's technical violations, which are maybe you didn't report, you tested positive for something, you didn't complete a condition on time, you didn't take a class on time. Those are serious violations, but not nearly as serious as what we call new law violations. New law violations mean that while you're on probation, you get arrested for another crime. I tell people the worst way to violate your probation is to get arrested for the same thing that you're on probation for, which I unfortunately see quite often, but there's still ways to get around it. But a condition of probation is not getting arrested. And the arrest in and of itself can be a violation of the probation. So a lot of times people say, well, I got arrested and my case got dropped. Oftentimes when the case gets dropped, the violation or the VOP will get dropped as well, but it doesn't have to, because violations of probations or VOPs have a different standard. When you get arrested for a charge, you're innocent until proven guilty. For most charges, you're entitled to a bond. And then you have the right to go to trial, and the state attorney has the burden of proof, and they must prove the case beyond and to the exclusion of every reasonable doubt. So it's a really, really high burden when you have a new case. A violation of probation is different. It's not a jury trial. It's a judge that's going to be making a decision on whether or not you violated, and the standard is preponderance of the evidence. So it's a much lower burden for the state on proving a VOP. So that's why just because a case gets dropped doesn't automatically mean the VOP gets dropped, although oftentimes it does. Sometimes people ask me how much time of probation can I be on. It really depends on the level of the crime that you're charged with. Florida, we've got second-degree misdemeanors. Maximum amount of time of probation on that is 6 months. For first-degree misdemeanors, the max probation time is 1 year. For third-degree felonies, the max amount of probation time is 5 years. For second-degree felonies, the max amount of probation time is 15 years. And then for first-degree felonies, your max probation time is 30 years. So those are your max times on probation for each case. Now, if you're charged with multiple charges, then the sentences or the probation sentence can run consecutive or concurrent. Concurrent means they're running at the same time. So you may have like 5 one-year terms of condition that are concurrent. That means you're going to do 1 year total. If the judge says 5 years of probation consecutive, that means they're going to stack. So it's going to be 1 year, that term that completes and you start the other year. So consecutive typically is not a good thing when it comes to sentencing. You don't want to hear that. Another question I often get is, what happens if I violate probation? And basically, when you are put on probation, and if you violate that probation, your exposure is the max amount of jail time that the particular level of crime carries. So I'll go through the levels again. For a second-degree misdemeanor in the state of Florida, if you violate your probation, the max amount of jail time, county jail time you can get is 60 days. Misdemeanors is going to be county jail, and then your felonies are going to be prison, or DOC, which stands for Department of Corrections. For a first-degree misdemeanor, your max amount of exposure of jail time is 1 year. For a third-degree felony in the state of Florida, your maximum exposure is 5 years. For a second-degree felony in the state of Florida, your max exposure is 15 years. And for a first-degree felony in the state of Florida, your max exposure is 30 years. Now, if we're talking felony cases, your exposure is going to be prison, or DOC, as opposed to jail time. And typically, there'll be a score sheet that you'll see, that your attorney will show you. It's a guideline for the judge to use with sentencing. And so it's a point system. And so you hear sometimes people say, how many points do I have? What that means is there's a formula that the state of Florida uses that gives the judge a set of guidelines on how to sentence. And if you have 44 points or more, that triggers prison or Department of Corrections. And so it's basically a mandatory sentence if your score is over 44 points. And that guideline is the judge. So you'll hear terms like bottom of the guidelines. Bottom of the guidelines is the lowest permissible sentence that a judge can give according to your score sheet. Now, there are ways around that as well. It's called a downward departure. And there's a statute that outlines all the mitigating circumstances that the judge can take into consideration when sentencing. So even if you score prison, doesn't necessarily mean that you're going to prison, but your attorney is going to have to do some work on showing either the state attorney for a negotiation as to why there are mitigating circumstances, or go to the judge and plead to the judge and ask as to why there are mitigating circumstances. And then, of course, there's also having a VOP hearing. You do not have to admit to a violation of probation. So if you find yourself in the status of a VOP, a violation of probation, and you want to fight it, then you have the right to do so. You have a hearing in front of the judge. Now, unlike a new law arrest with a violation of probation, you're not entitled to a bond. And so oftentimes, if you violate your probation, especially with a new arrest, you'll see what's the bond. There'll be a zero bond, which means there's no bond. So your attorney will have to have a bond hearing, file a bond motion, and then request a hearing. And sometimes the judge won't even allow that. A lot of times it varies county by county, but just know that with the violation of probation, you're not entitled to a bond, although you can get one sometimes if the good arguments are made by your attorney. Okay, I'm talking kind of fast, sorry. But if you guys have questions, you can feel free to type them in. Mariska, I can't see. I have Mariska's, she's helping me in the background here. I can't see the Facebook questions, so if there's any, just type them in the thing and I will answer them. Okay, thanks. All right. Another question I get a lot is, can I early terminate my probation? And how do I go about early terminating my probation? And answer is yes. Typically, probation can be early terminated. And what that means is, say you take a plea or you're sentenced to 5 years of probation, and you're doing really well, and you want to early terminate, which means end it early before the 5 years is up. You can request that it be done. It is not automatic. A lot of times people think like, okay, my probation said that I had to do 20 hours of community service. My probation officer said I had to take a battery class or a DUI class. I completed the class. I'm done. Probation should be done. While I agree probation should be done, it doesn't work like that. You actually have to file a motion in court, and it's called a motion for early termination of probation. And then the judge will either sign it in chambers, which means you don't have to have a hearing. The judge will read the motion and decide whether or not the early termination should or should not be granted. or the judge can, if you're attorney or you request a hearing, you can have a hearing on the matter. The most efficient and effective way to get an early termination of probation granted is to get the position of your probation officer and the position of the state attorney. If they're both in a no objection status or stance, which means they don't object to the early termination, then a lot of times the judge will go ahead and sign off on the early termination of probation. There are statutorily, there are some requirements. It's one is that there are no prior violations of probation. Another one is that all terms and conditions are complete. And then another one is that you're at the halfway point. So say, for instance, you got 5 years of probation, you're at 2.5 years, and everything's finished. There really shouldn't be a reason as to why an early termination is not granted. Again, probation and even the early termination of probation is not considered a right. It's a privilege to be on probation. It's like hard for me to say that, but whatever. Also, getting your probation terminated early is a privilege. So it's not an automatic thing, but typically if those requirements are done, your terms and conditions are complete, you're at the halfway point, and you have no prior violations, then you're typically going to go ahead and get that termination, early termination granted. Again, it does not happen automatically. A lot of times probation officers will have a good relationship with the people that they're supervising, and they'll say, hey, I think you should get your probation terminated, which is great that the probation officer suggests that. But just because they suggest it doesn't mean that it automatically happens. It's something that the judge has to sign off on. Now, I've seen both ways. I've seen early terminations get denied at the halfway point, even though all the requirements are met. I'll tell you why. I've also seen probation terminated early without some of those things I talked about. And I'm going to tell you why too. I'm going to start with the bad news, which is why, if I'm halfway done with my probation, all of the terms and conditions are complete, and I have had no prior violations, and I file my early termination and it gets denied. Why? Most oftentimes when I see that happen, they are cases that involve a victim, and the victim has an objection, or there are cases that involve some sort of negotiated plea on the front end, and part of that plea indicated that there would be no early termination of probation. And that happens sometimes. I've had cases where there was a victim in the case that was still in fear of my client. My client wanted to take the plea, and so the victim in the case wanted the most probation possible, and no chances to early terminate. And so in an effort to avoid prison or jail time, that was negotiated, but it was put in the plea that an early termination could not happen. And so it's those types of cases where you typically see the early termination not get granted. Now, it doesn't hurt to try, and we can still try to ask for the early termination. But typically, you're going to see the state attorney respond with an objection to an early termination when there are victims involved with the charge. Now, on the other end, I've had cases where the only condition of probation is restitution. Say, for instance, I've had a criminal mischief case in the past where there was some damage done to someone's car. They were basically just put on probation for the purpose of paying off the damage. It's like $500. And so judge is like, okay, I'm sentencing you to probation. You have to pay, while you're on probation, you have to pay the $500 damage. $500 gets paid off in the first month. There's really no purpose of being on probation. And so I have filed motions to early terminate, even though we're not at the halfway mark, because the sole purpose of the probation was to get that condition done, which in that particular case was the restitution paid. So I have had cases where I've been able to get the probation terminated early on, and that's prior to the halfway point. I will say that's something that can also be negotiated in a plea or even during sentencing. And so if you have a feeling or you know that your client or if you know that you're probably going to be able to finish the terms and conditions of the probation early, even before the halfway point, you can try to negotiate that and put that in the minutes, which is basically what happens in court for the day. You could put that, judge, can we put in there that there's no objection to an early termination as soon as the conditions are met? That way it makes it a lot easier on the back end to get the early termination granted. Another time I've seen kind of like an exception to the rule is if like fines are crazy. So for some of your drug trafficking cases, there are statutory fines that are just like crazy, like tens of thousands of dollars, right? And so my client will have all of their terms and conditions complete, but they have $25,000 of court fines is the only thing that's remaining. Well, you can request an early termination even though all the terms and conditions aren't complete because those fines aren't paid, and you can request that that money be transferred into a civil lien, which is basically saying that they are civilly liable for the monetary amount, which having a civil lien is not great. Your license can be suspended, your credit can get jacked up, but you're not on probation anymore. So, you want to avoid probation if you can, right? And if you're on probation, you want to try to early terminate as soon as you can as well. So that's as far as early termination of probation is concerned. Those are the ways that you can early terminate. Again, that is a service that we offer. Even if I did not represent you on the original case, I can still represent you. People hire me all the time to just come in and file a motion to early terminate the probation, and I get it done all the time. And basically what I do is I reach out to the probation officer, I get their position, forward that to the state attorney, get their position. Ideally, I try to file unopposed motions to early terminate because those are the ones that get granted most likely. But even not, if even a state attorney or the probation officer objects, we can still file the motion, we can still have a hearing and put up a good fight for the termination to be granted. All right. Another question I get is if you're on probation, can you get your records sealed or expunged? So the answer is no. To get your records sealed or expunged, your case has to be completely closed. And so your case is not considered closed if you're still on probation. So no, you cannot get your record sealed. You cannot get your record expunged until probation is complete. Once probation is complete, whether it's because you served the entire duration or if it's because you got early termination of probation, that is what officially closes your case. And then you can start the sealing and expunge process if you qualify. Okay? In the state of Florida, you can get your case expunged if it was dismissed. And then some charges are eligible to get sealed if you receive the withhold of adjudication. Another requirement is that you have no prior convictions on your record as well. I think I've done a live prior to this one on sealing and expunging, but if you ever have questions about sealing and expunging, of course, give us a call. It's an opportunity to have a second chance. It's an opportunity for when jobs are searching for your background, or maybe like you're applying for an apartment and they want to do a background check. If your record is sealed or expunged, they don't have access to that, so it won't be used against you. So that's pretty much the ins and outs of probation. The last question. Oh, hi, Lacey. Hi, cousin. Hi, Nicole. Hi, guys. Love y'all. The last question I'm going to answer is probation a good idea? And like lawyers can't really ever answer anything yes or no because everything is complicated, right? It depends. I have some clients who I'm like, sis, bro, probation is not for you. You're gonna violate. So no, I don't necessarily think that probation is a good idea for everybody. I do think that it is an opportunity for some people to take advantage of, to avoid jail time or prison time. But it can also be a setup. When you take probation, the way I describe it to my clients is you're literally signing a contract that says, I'm going on probation. And if I get in trouble, you can sentence me to the max. So say, for instance, in a third-degree felony in the state of Florida, it doesn't have to be like a serious charge. Like driving on a suspended license as an habitual offender is a felony in Florida, which blows my mind, but that's a legislative issue for a whole nother day. But that is a felony, right? You can literally be driving your car with a suspended license, and it is considered a felony. So you take probation because you're like, I don't want to go to jail. Okay, but if you're on probation and you violate, then you are subjecting yourself to 5 years in prison. 5 years, right, for a violation, and a violation is just stupid. And so I always tell people, I was a PO for 2 years. Everyone is not a candidate for probation. Yes, let them know it is not for everybody. Some people are great. They can do probation, no problem. But some people just have like tunnel vision. Like it can get, especially like if you have someone that's in jail, right? And they're just really anxious to get out of jail, which is understandable. Who wants to be in jail, right? And so they're like, I'm willing to plead to anything. If I can just get probation, I'll sign it right now. And I've seen it so many times where you'll take a probation offer and then violate in a month. Now you're back in jail. Now your exposure is high. Your score sheet just shot up and you're going to prison. And so probation is not for everyone. I think that it is important to make sure that you have an attorney that explains exactly what it entails. It's important if you have support. That's obviously helps a great deal. If you are on probation, I encourage people to watch the company you keep. I've had so many people that get in trouble, not for something that they did, but for just being in the wrong car or being at the wrong house or being with the wrong person. And you're the one that's on probation. And then everybody gets arrested, even though you didn't do anything wrong, but you're in this car with something in it that you didn't know was there. And now you're in a violation status. And now you're facing 30 years in prison because you're on probation for a crazy charge, right? And so if you do decide to take a probation plea, or if you are sentenced to probation, then you want to be extra cautious because, like I always tell my clients, the worst way to violate your probation is to get arrested, especially to get arrested for the same thing that you're on probation for. I'm not saying it's impossible to get you out of trouble. And if there's a way, I will figure it out. But it just makes it really, really hard. So that's it. That's my spiel on probation. I hope the information was helpful. I love you guys. As always, it is my pleasure. It is my honor to serve this community. I still, after how many years I've been doing this, since 2008, however old that is, I still love what I do. I still love coming to work. And so tomorrow's my birthday. Woohoo! And I'm coming to work because I love coming to work. So thank you guys for tuning in. Again, at Hom Law, we are a full service practice. We specialize in criminal defense, immigration, and family law. So if you're running from the police, immigration, or even your spouse, keep calm and call Hom. Our number is 407-802-3223. Thank you guys. Have a wonderful day and stay out of trouble. But if you do get in trouble, give me a call. Woo!